eccentric. It is eccentric. Good afternoon. Welcome to the Appellate Division First Department. Before I call the calendar, I want to let you know that Justice Moulton is actually present. He's here virtually. So just make believe that he's sitting up here with us. If he has any questions, he's going to text them to me. And if I find them to be relevant, I'll ask them. Just kidding. I will ask any questions that he texts me. I promise I will ask them on his behalf. People v. Omar Hernandez. Submitted. Wormser Corporation versus L'Oreal USA.
Wormser Corporation, 6 and 3.
5 and 2 and 5. Roslin versus ACS. Submitted. Fata versus Shea. Would you like to submit? Submitted, thank you. Prac versus New York City Transit Authority. Do I have a respondent? Did you wish to submit or did you wish to some time? Okay, 5 minutes. Haley Insulation versus Turner Construction.
Appellate 82.
Okay, so 6 and 2, 6 and 4. People v. Julian Horry. Submitted. Rob v. Rob. 5, 2, and 5. Jilombroski, I apologize, versus Port Authority. Yes? How much time did you want? I'm sorry, I didn't hear you. Oh, sorry. 6 and 2 and 6. Chaudhry versus Phillips. 6, 2 and 6. Fernandez versus Mercy First.
Appellate 5 and 2. Respondent 5, please.
5, 2 and 5. People v. Donovan Brown. Submitted. Kuffeld versus New York Presbyterian. Hi. Who are you? You're the respondent. Would you like to submit?
No, I'd like to briefly just
2
2 minutes.
minutes. Skurick versus Montefiore Medical. Submitted. First case for argument, Wormser Corporation versus L'Oreal.
Ready?
Proceed.
May it please the court, Russell Bogart from Kagan, Casperson, and Bogart PLLC on behalf of the appellant Wormser Corporation. This case arises from the respondent L'Oreal USA having filed suit 3 times in the state of New Jersey seeking to recover $65 million due to Wormser's alleged breach of implied warranties.
Was there a final determination made in New Jersey?
The determination was changed to being without prejudice by the appellate court in New Jersey. So there's been no New York State decision that has ever applied res judicata to the set of circumstances here. One, where the prior dismissal was without prejudice, and secondly, where the dismissal was issued in response to a pre-answer motion to complaint in which the defendant in the prior action never even filed a pleading.
Counsel, even assuming you're correct with respect to res judicata, doesn't your request, in essence, is for attorney's fees, doesn't that sort of go against what our rules are? You need statute and contract to recover attorney's fees.
In the Indo-Suez decision, this court 19 years ago recognized an exception or held that the American rule doesn't apply when a party...
Is that case distinguishable from our facts here?
No, Your Honor. I believe that in that decision, Justice Andreas, when issuing the decision for the court, cited to two federal court decisions that had the same, very similar fact pattern involving a lawsuit that was filed in the wrong forum and then a breach of contract action filed in the second forum seeking attorney's fees stemming under a breach of contract theory. And the American rule only applies to claims for attorney's fees that are incidental to litigation. It doesn't apply for direct or consequential damages. And the Indo-Suez court, as many state courts around the country have interpreted the American rule, held that the breach of the forum clause is a breach of contract claim and it's consequential damages. So, you know, the highest state courts in California, Delaware, Texas, Oregon, Indiana, and so forth have subsequently followed Indo-Suez and adopted the same reasonable distinction. We also think that the allowing of the award of attorney fees promotes important public policies. It makes the non-breaching party whole. It discourages forum shopping. Here, this was a standard supply agreement imposed by L'Oreal upon all of its suppliers, and it preserves the expectation of the parties. And so, you know, L'Oreal's res judicata analysis, to go back to the first issue, suffers from the flaw that they cannot cite to a single case in which a New York court has applied res judicata where there was a dismissal without prejudice, and two, the first dismissal was procured on a pre-answer motion to dismiss the complaint. In New Jersey, the rule for counterclaims doesn't even apply unless the defendant has filed its initial answer. And that was addressed in the Bank of Luimi decision in addition to the entire case doctrine. So unless your honors have any more questions, I'll reserve the rest of my time.
Thank you.
May it please the court. Anthony LaRocco, K&L Gates, on behalf of the respondent L'Oreal.
Isn't counsel correct that there has been no determination on the merits and therefore res judicata does not apply here?
He is incorrect, Your Honor. That was the first point I was going to make. What counsel has failed to advise the court is that the without prejudice dismissal relates solely to L'Oreal's claims that were preserved from the New Jersey court into this court, into this jurisdiction, into New York.
The dismissal was without prejudice, the dismissal of the complaint. They have not had an opportunity to file anything, so they are availing themselves at this point to seek damages for your breach or your alleged breach of contract.
No, Your Honor, I think there is a distinction here. The with prejudice status is with respect to the very issue that they raised on the motion to dismiss, and that is subject matter jurisdiction. The court necessarily, in raising that issue, Wormser necessarily put at issue the substantive issue of whether the underlying supply agreement was breached by virtue of L'Oreal's conduct with respect to the forum selection clause. That issue was determined to be final, and it was ruled against
So in other words, your dismissal is without prejudice and the dismissal against him is with prejudice. Frankly, that there seems something inconsistent with that position. It's either all of one or none of both, no?
No, Your Honor. This is, granted, this is a unique case. Let me just set the table
Well, it's
up.
interesting. I mean, it's your supply agreement that you allegedly breached by bringing in action in New Jersey when you should have brought it in New York. Why shouldn't they be entitled to recover consequential damages for that breach?
Because, Your Honor, the law is clear in New York. There were only 3 instances where we have a supply agreement it is undisputed that the supply agreement has one sentence with respect to damages, and that is each party is responsible for direct damages. There's no definition as to what direct damages is. There is no fee-shifting provision in that agreement, and there is no court rule, there is no statute, and there is otherwise, obviously.
But what about the case laws recited by counsel, the Indo-Suez case, which, according to counsel at least, is now followed around the country?
Your Honor, I think the Indo-Suez case is either it stands on its own as perhaps an aberration of this roughly 200 years of jurisprudence, but I think it can be reconciled. It's one sentence, and it says, contrary to defendant's contention, damages may be obtained, not are, as a matter of law, required, all right? And it cites the Allendale case, for example, and it cites the Allendale case simply as an example. In that case, there was a situation where a judgment had already been had in England, and there was for expenses. And the court said in that instance, because you couldn't bring that issue here, as the court stated, that under English law, the plaintiff in that case was entitled to seek the expenses that, under full faith and credit, that English court awarded. That's a different situation that we have here, Your Honor. I think that sentence, which has no analysis and possibly is dicta, I think it is reconcilable
We
in
should
light of...
ignore the sentence and say the American rule applies here, and therefore...
Yes, I don't think you need to ignore it. I think it's reconcilable. Here, in this case, the contract itself is silent as to fee shifting. There's no express, unambiguous statement as to who is responsible for the fees. In the complaint itself, Wormser says res judicata applies. It says it 3 times, that there was a final adjudication on the merits with prejudice, and I can cite the court. There are 3 separate instances where, in the underlying complaint, Wormser says that. So therefore, it addresses the issue of finality with prejudice. Secondly, in the complaint, it addresses the attorney's fees being sought as consequential damages, not direct damages. And we have to abide by the supply agreement, which is a general statement in one sentence, and consequential damages is not direct damages, and case law indicates that also an attorney's fees in this particular setting is special damages, not direct damages. So, Your Honor, I think under the facts of this case, you can reconcile Indo-Suez for that proposition. It's different. It's clearly, the facts are clearly distinguishable. The Allendale case sets up a very unique situation, but I think 200 years of case law, it's settled in this jurisdiction that the American rule applies. You have 3 instances where you can allow for attorney's fees in the context of this case: contract, express, unambiguous, statute, and court rule. Thank you, Your Honor.
Thank you.
The Bergen County Trial Court did not decide the same issue presented by this case. The Bergen County Trial Court did not decide whether this honorable court 19 years ago properly decided the Indo-Suez decision. And it would violate principles of comity to appoint a New Jersey trial court judge to sit like an appellate court and decide whether this honorable court reached the proper decision 19 years ago. With respect to what did Indo-Suez intend, I think it's very clear by the citation of the 2 decisions cited therein, the Allendale decision and the Laboratory Corp decision, both of which clearly held that attorney fees can be recoverable as damages for breach of a forum selection clause. We think that under principles of stare decisis, which have not even been addressed by the respondent, that this court should follow and adhere to Indo-Suez, which was properly decided.
Thank you. Thank you both. Crack versus New York City Transit Authority. You may proceed.
Good afternoon, Your Honors. Joel Rubenstein for Plaintiff Appellant. Your Honor, it's easy for a party to say that facts are in dispute, but that doesn't make it so, especially when, as in this case, there's photographic evidence that clearly establish facts and clearly make one version of events incredible. And I'd like to, if I can, to walk you through the photographs that establish how this accident happened, where the cars were, and make it clear for the court. In the record, 510 is a map that shows the layout of where this accident happened on East Gun Hill Road at the intersection of East Chester.
Right, and so the testimony, I understand, was that there was no dedicated bus stop, and that the bus actually was in what would be the farmost right lane. Is that correct?
No, Your Honor. The testimony is that the bus driver testified that he was in the bus stop, remained in the bus stop the entire time, continued into the intersection, partially in the bus stop and partially in the intersection.
Right, but I thought there was also testimony that there was no bus stop.
No, there's no testimony to that. What there's testimony to is that they labeled the two lanes to the left of the bus stop. They said there was only one lane and labeled it a left lane, even though there are two lanes for travel, and that the bus stop is not a travel lane. And the bus driver himself, when shown plaintiffs 8 from the deposition and 5, which is 510 and 511 in the record, clearly said that there are both two eastbound traffic lanes, to the right of which is a bus stop. And he actually circled on record 511 the line separating the two lanes from the bus stop. And if you turn to 510, you can clearly see a bus, not our bus, but a bus in that bus stop stopped.
But why does that matter? Isn't the issue here, the claim is that the bus was moving, right? And when the bus was moving, according to the transit authority, when the bus was moving, the car came around and cut the bus off. Now, there are two versions of that accident. Why isn't that an issue of fact? I know you say it's incredible, et cetera. Why isn't that sufficient to go to the jury?
Because there are not two versions. The version is that the bus was in the bus stop.
But it was moving. Wasn't the bus moving? The claim by the
He was exiting the bus stop and merging into a traffic.
moving. The
But
bus
if you're
was
exiting the bus stop, you have to be moving, right?
Yes, so he was
it's
moving.
So the bus is moving, and according to the bus driver, the plaintiff comes from behind and cuts the bus off.
But the bus driver cannot move until it is safe for him to move from a stop
Well,
position.
that's the whole issue, right? Because the bus driver is basically stating that your client came out of nowhere and cut it, sped up and basically cut in front of the bus.
That's not at all what the bus driver is saying. The bus driver said that he saw my client the entire time in his rearview mirror.
Right, and then your client, according to the bus driver, we weren't there, according to the bus driver, your client comes around the bus and cuts the bus off.
My client made a right turn from the right traffic lane, and the bus is not permitted to move from a bus stop, which is not a travel lane, until it is safe to do so. The fact that there was an accident shows that it wasn't safe for the bus driver to move his bus.
So in other words, every time there's an accident, that means the bus company is responsible?
It means if the bus is not in a bus travel lane, but is in a bus stop, before it merges back into the travel lanes, it must, as a matter of law, under 1162 and 1128, make sure that it is safe to do that. He's not allowed to move from a stop position.
And if a vehicle comes out of nowhere, how is it therefore the bus driver's fault?
Your Honor, the bus driver states that he saw the bus on his left, in the left side, in his left mirror, behind him in the traffic lane before he exited the bus stop. How can that be out of nowhere? He can't see
And the
it.
next thing that occurs is that your client is making the right and collides with the bus.
Right, my client was making a legal right from the right turn. The bus, before my client started that, the bus saw my client. The bus was not, at that point when they saw my client coming in the rightmost travel lane, was not permitted to leave the bus stop. You're not allowed to move.
Right, and so you see what we have here are issues of fact.
What are
right?
the issues? The bus driver is not permitted to move from the bus stop.
If the bus is already moving,
It wasn't already moving. It was stopped in the bus stop. That's the testimony.
Yes, but you acknowledged a minute ago that the bus then was moving out of the bus lane, that you say is a bus lane, into the lane of traffic, and you say that was done negligently.
But the bus driver saw the car before he started to move. If he saw my car going straight in the right
You saw the
traffic
car behind the bus,
yes.
correct?
Your Honor, if you're going to merge from one lane, you look behind you, you see if there's a car coming. If there's a car coming, you don't merge because it's not safe. The bus driver saw a car behind him, was in a stop position, and decided, well, I think I'm going to go anyway because I'm a big bus. And he went into the intersection and he hit my car.
I didn't see anything about a big bus in the record, but thank you very much,
Your
Counsel.
Honor, is that a...
Appreciate it.
Thank
Haley Insulation versus Turner Construction. You may proceed.
Thank you, Your Honor. May it please the Court, Douglas Lutz, Wasserman, Grubman, and Rogers for the appellant. All the applicable case law in this case, when interpreting Lien Law 70 sub 1 and Lien Law 2 sub 8, basically states that if a lessee of a space that he leases from a government entity, publicly owned land, and that he does nothing more than build out his space, he is an owner under 70 sub 1 and therefore not a trustee. Even the cases cited by the respondent told us. In Canron versus City of New York in 1995, this court noted that a lessee who, with the owner's consent, performs repairs upon a demised property is for purposes of lien law an owner and not a contractor or a
Counsel,
subcontractor.
Even assuming that's correct, couldn't your client be considered a contractor under the lien law as well?
No, because under the cases from this court and other courts, is in order for it to be, you have to find a contractor. It has to be work in addition to
How does
demised
the lien
space.
law define the term contractor? Does it define it in the manner that you are espousing, or in some other manner?
The lien law 2 sub 9 says the term contractor, when used in this chapter, means a person who enters into a contract with the owner of real property for the improvement thereof.
Okay, so let me stop you there. Does your client fit that definition of the lien law?
No, because in Canron, in the City of New York.
No, just put the case law aside for a second.
Okay.
Do you fit that definition?
No, not in this case, because all our client did was he received a space, he hired contractors to build out his space for him.
In other words, you're not a person who entered into a contract with the owner here of real property to improve, to make this beautiful hotel at JFK?
If that was if you take that interpretation of the statute, you're basically saying that every lessee in the city who rents out space, as soon as they do anything to build out their space, they're automatically a contractor, and the distinction that the state legislature passed in saying this is an owner, this is a contractor, owners cannot be trustees for improvements of publicly owned property, but contractors can, would mean nothing.
But conversely, to accept your position, we would impose on the statute language that's not present. For example, that in effect the owner must act like a GC, hire subs, et cetera, no?
But that has been the interpretation by this court and other courts in the state of New York. Canron, this court stated that when a lessee does work on the demised premises with the consent of the owner, it is considered not a contractor under the lien law. It's considered an owner. And that's why the decisions in this case say the issue becomes, did that party act as a contractor in addition to being an owner? And how the courts have done that is by saying, have they done some work in addition to building out their space? In Canron, the city leased the marine terminal to the lessee. But the city also stated, if any damage happens to any part of this property, we can take it back and do the repair ourselves. storm damage occurred, the city said, we're going to hire you to repair the damage that we are supposed to do underneath the contract. In Tudor Perini, another case cited by the respondents, in that case, it was, again, additional work. The developer had received the property to build out his space, the bus station, and also received money to build out other space, shops and other spaces that he would then give back to the MTA to rent out. In Gilbane, again, the court, which is an unreported decision, so the record's sort of sketchy, but even in that one, the court said, we have to decide, are they also a contractor in addition to an owner? And in that case, the other side presented sworn testimony, affidavits showing that they had done work as a contractor. And I believe in that case, Gilbane, besides submitting an affidavit, also found evidence from another case where the owner had admitted in another case that they themselves had done aspects of the project, had done contractors' work, and had suffered damages in another case. So every case that goes here basically says that it has to be an additional work. And here, there is nothing in the record. It's not in the complaint. It's never alleged that Flight Center did anything other than be an owner. Even after the motion was made, neither respondents tried to change their pleading to allege they were a contractor, did contractor work. They didn't submit any affidavits, didn't submit anything to say, yes, Flight Center did something other than just being a developer, hiring people to build out the space. I can see my time's sort of ending, so I'll reserve my time.
Thank you.
May it please the court, Martin Gold for plaintiff respondent Haley Insulation Corp. In reference to the first question that Your Honor asked, Article 70, subsection 1 of the lien law provides that an entity that receives funds for a public improvement is a contractor, and it becomes a trustee under and the assets of the trust. And the complaint alleges that both defendants were, that the plaintiff was a trust beneficiary of both defendants. And I think that the record, page 84 of the record reflects that Flight Center was not merely a developer, which they say can't make them a contractor. They hired the architects, they hired the engineers, and then they hired Turner.
So how do you, your adversary says the Canron cases, other cases are distinguishable because in those cases, the owner was in fact acting like a contractor and therefore certainly some circumstances that would apply, but not in this case.
I think that the OTG JFK case is directly on point because JetBlue leased the premises from the Port Authority, just like FCH, Flight Center Hotels, did in this case. JetBlue then turned around and subleased it to someone else who hired a construction team to build it out. And the court held that OTG was liable as a trustee, as the lessee. Just the important point is not that it's a lessee. The owner is the Port Authority, and the distinction between a mechanics lien under Article 2 and a trust under Article 3A is that the trust doesn't affect the right or title of the owner's property, that being the Port Authority. There's no lien on the property. There's a lien on the trust assets. And I think that's an important distinction because it protects the subcontractors and it protects the workers, but it gives the Port Authority, it doesn't bog down their title. So I think the OTG case is directly on point. Thank you, Your Honor.
Thank you.
Good afternoon, Your Honors. Mark Snyder from Picard and Abramson on behalf of defendant respondent Turner Construction Company. We briefed the limited issue as to whether or not Flight Center constitutes both an owner and a contractor for purposes of Article 3 of the lien law. because that provision of the lien law is the only provision at statute that protects Turner in these circumstances where they're performing construction work on land that's owned by a public entity but operated by a private entity. So on page 13 of Flight Center's opening brief, they argue that the Port Authority is a public corporation as per the statute. They then say that they lease this property from the Port Authority. What they don't say and what they don't refute is that the lease in question is the lease and development agreement, whereby the Port Authority obligates Flight Center to make design decisions, to make construction decisions, to hire
Are
contractors.
you arguing that in effect they're a contractor?
Yes, Your Honor. They're both an owner and a contractor for purposes.
Well, they're a lessee and contractor, they're not an owner.
They're an owner by the virtue of their lessee status, Your Honor, yes. Yes. So it's because of this dual status that's afforded to them that contractors like Turner and the subcontractors, potentially as Haley, are protected by the statute. This court said in Canron, and I should first make the important distinction in Canron. In that case, there were two separate agreements at play. There was the lease, and then there was the subsequent construction contract to make the repair work. In this matter, it's the same contract. This court doesn't have to search through two separate contracts to try to bridge that attenuated gap. It's all one and the same. And Flight Center didn't place that contract at issue on the motion to dismiss. And it's also an important point to make because Turner did not obtain a copy of the lease and development agreement until it filed an order to show cause to compel its production in a separate and related matter in New York County, where we got the redacted copy. And the court in that, there was a decision order written in that, and the court relied in part on the lower court decision in this case to find that Flight Center is both an owner and a contractor, and thereby find that the lease and development agreement was pertinent to the matter. And so that's why the allegations, the argument was based on information and belief. The record is devoid of the lease and development agreement because the only party that had it in its possession at the time the motion was briefed chose not to put it into play, right? So in Cameron, this court said that to find the lessee in the situation where they're both the lessee and the party performing work to not be a contractor and thereby place it outside the scope of the protections afforded by Article 3A of the lien law is both contrary to the protective intent of Article 3A of the lien law and offensive to the principles of equity. And to find that Flight Center in this matter is not both an owner and a contractor would both violate the protective intent of Article 3A, and it would similarly be offensive to the principles of equity. Flight Center obtained at least 2 commercial loan agreements, hundreds of millions of dollars, to pay for the construction work performed by Turner Construction. They have to be trust funds. That money is designed, it was given exclusively to pay for the development on public land. That land is the money that is obtained by Flight Center to pay for that development are trust funds. Thank you, Your Honors.
Again, the issue here, there's a difference between when you can file a lien and when you're considered a trustee. OTG, on that case, evidence was presented that they did work.
You know, you keep talking about evidence, but I want to remind you, this is a motion to dismiss, and first we have to assume, for the purpose of the motion, the truth of the allegations, right? Does the development agreement actually impose upon you additional obligations under which you might be considered a contractor?
Well, the development agreement is not part of the record.
And why is that not part of the record?
Because
you chose not to put it in?
No, because the complaint, the only allegation in the complaint concerning FCH is it's a hotel development company created by its parent company, MCR Development, in conjunction with Morse Development. Paragraph 11 is the only thing related to any factual allegation into this is the project was situated on land owned by the Port Authority of New York and New Jersey, but was under long-term lease to FCH. That's it. There are no allegations anywhere on the record that about Flight Center beyond that. And so therefore, based on the allegations of the complaint.
How are they to make those allegations if they don't have a copy of the development agreement?
In Gilbane, the contractor was saying, well, we want the owner to also be involved as a trustee. They submitted an affidavit saying the owner, we are on the project, we were at the project, we can state that the owner did X, Y, Z, and went down. As I stated before, the contractor also said, here is another companion case where the owner, in another case, said, yes, we did contracting work, and we want damages because the subcontractor there delayed the project. Here, there's none of that.
But there are allegations that you were to construct, to design and construct. Are there not allegations in the complaint as to that?
No, there isn't. It says, defendant FCH is a hotel development company created by its parent company, MCR Development, in conjunction with Morse Development. Next paragraph, in or about 2015, Turner was hired by FCH to construct a TWA hotel project and conference center located at the old TWA terminal at JFK Airport in Queens. 11, the project was situated on land owned by the Port Authority of New York, New Jersey, but was under long-term lease by FCH. Nowhere else does Haley state that, even to Haley's work, that Flight Center was involved. They make lots of allegations against Turner about they didn't follow their own plans and their own rules on how to make sure subcontractors got paid. They don't mention talking to Flight Center at all. Turner, who was on the project, like the case in Gilbane, they could have said, hey, we were on the project. Here's sworn testimony to do it. The
Counsel,
could have
I
submitted
just have a
full
question.
affidavits.
Counsel, I have a question. You know, where in the lien law is it even required that the party actually acts as a general contractor and then engages subcontractors? I mean, where is that language in the lien law?
The lien law 71, when it says who can be a trustee for owners, states it's only for real property in New York, and then later the legislature amended it to add like home improvement liens.
But that's not the answer to my question. I'm saying, you know, the section that we're talking about, 2.9, I mean, where does it say you have to, you know, be a general contractor, you have to engage subcontractors? I didn't see the language. Maybe you can point me to something else.
In 70 sub 1, they say the differential between a contractor and an owner and a subcontractor. 2.8 defines an owner, and 2.9 does a contractor. And under the general rules of interpreting the lien law that all the courts in this state follow is, you have, the statute has to expressly impose an obligation on a party. Of course, it's creating a new cause of action. Every case says that. You can't impose duties on people unless the statute specifically states that, and none of that occurred here. And there are no allegations anywhere on the record. Everything that Turner's attorney stated is nowhere in the record. It's not in the pleadings. It wasn't in the pleadings. It wasn't in any of the motions.
Thank you very much. Rob v. Rob.
If Your Honors, please, Ed Guardaro, Fullerton and Beck for defendant appellant George Robb. Your Honor, the first issue I believe we have to address is the leave to amend motion. I would submit to the court that the leave to amend should have been granted under the circumstances here. It's used to be that it was freely granted. Here there was an argument that it was late or that it was...
So it was 2 years later, is that correct?
That is incorrect, Your Honor. The note of issue was filed May 6th, and the motion to strike was May 19th. Moved to strike they moved to strike the note of issue because it was premature. The actual on page 137, you'll see deposition testimony of Mr. Robb, the defendant, on page 137. That's on actual April 26th, where at the very end on page 137, plaintiff's counsel says specifically, we're not ending this. This is just for today. So then 10 days later, he files a note of issue. So we move to strike it. So under the circumstances, this whole theory about it's late is really a misnomer, especially in the fact that even to this moment, the motion to strike has not been decided. There's even a motion for a preference that hasn't been decided. Justice Kaplan said that this is on the eve of trial. The fact of the matter is there's never been a trial date. There's never been any scheduling of that whatsoever. Justice Kaplan's now been, the case has been moved from Justice Kaplan to another justice. So we're not looking at a trial in this case for quite a long time. And as we speak, there's still ongoing non-party depositions which were agreed to at this time. So the question of this lateness, I believe, is a red herring. It wasn't on the eve of trial. There's no prejudice under the circumstances. The plaintiff knew of the defendant's age. That's on page 43 of the transcript.
But didn't, the defendant knew, was aware of the defense, counsel was aware of the defense. Why wait till after the deposition to even attempt, putting aside the issue, note of issue, to attempt to bring in an expert at that time?
So the timing of the deposition is actually critical, Your Honor. The plaintiff had not finished questioning. There had been these admissions of this conduct. Defendant, counsel, had intended, under all circumstances, to question the defendant to explain what was going on, more specifics about when, what, where, and how, when this happened, the age issues, what he was going on mentally, and what was going on. So all of this came as a surprise to the
Your
defendant.
defense counsel was going to question his own client at an EBT to get
Yes, Your Honor. It's not a question, these aren't surprises, Your Honor. The fact that there were admissions
Actually, tell me what were the admissions in this case?
the admissions were that prior to the time that both the plaintiff and defendant were of age.
Well, just give me the precise ages, because there's some confusion in my mind, at least with respect to the admission.
Well, I'll clear up any. I believe the allegation is that it began when the defendant was 8 years old and the plaintiff was 4. And it went until, the defendant says, it went till before he was 16 in 1972. I believe the plaintiff states that, and during the argument, there was an issue as to whether or not it continued to his 18th birthday.
And so what was did he admit or did he concede that it did continue until his 18th birthday?
No, Your Honor. And he never admitted that what he did was criminal or wrong. He just
Well, he said he didn't know it was wrong. He said he did not know what he was doing was wrong.
It's uncontested, Your Honor, at this point. Dr. Ferneri's affidavit stands
But
alone.
with respect to the sexual contact, I just want to understand with respect to the sexual contact. So your client admits essentially to sexual contact from the age of 8 until sometime when he's 15, turning 16.
Correct, Your Honor.
Okay.
That's correct.
And plaintiff's position is it occurred through 18.
Yes, Your Honor. The plaintiff urges that
That
after this argument, and that's why the whole mental capacity issue was brought up.
So I have a question from Justice Moulton. Doesn't the CVA include explicitly, quote, predecessor, criminal, unquote, criminal statutes if they pertain to actionable conduct, but did not include any mention of predecessor statutes that pertain to defenses like infancy?
Your Honor, that's an exact quote from the plaintiff's argument. I would say, does the CVA say that? No. The CVA addresses the questions only in the context of criminal trigger. That's been found by CO versus Diocese of Brooklyn, Justice Silver, SH Diocese of Brooklyn, again, Justice Silver, Holloway versus Holy See, Federal Court, Southern District 2020, and Jeffrey versus Andrew, again, 2021, Southern District. There's no question under the circumstances that this statute has to be interpreted extremely narrowly. That's this court's determinations in Besser versus Sinus and a series of others. I would submit to the court that the defenses apply, that there are specific arguments and allegations that it applies to civil cases. That's not the case. It specifically says it in there, and I think the court has to look at the statute very, very narrowly.
Thank you.
Thank you, Your Honor.
May it please the Court, I'm Annette Hassapidis, appearing for the plaintiff respondent in this case. The lower court's determination should respectfully be affirmed. First, the defendant has not challenged the lower court's denial of the summary judgment motion as made more than 140 days after filing the note of issue without an explanation for good cause. Defendant's brief only refers to the timing of the summary judgment motion in the factual portion of his brief, but raises no challenge to it. So he's placed it beyond the court's review.
Do you agree with counsel with respect to the admissions that there was defendant has conceded or admitted to sexual contact between the ages of 8, essentially up to 15, 16, but not between 16 and 18, whereas your client says it occurred up till the time he was 18.
That's correct, Judge Singh. My client
Okay, I just wanted to be sure about that.
Yeah, so I was just going to provide the court with the page references of the testimony if you want it. My client's testimony with respect to when it concluded was at page 466 of the record. Defendant's testimony concerning the timeline was at page 46, 82 to 86, and 121. Thank you.
Thank you.
Thank you. Next, the court did not abuse its broad discretion in denying the motion for leave to amend to add a statute of limitations defense. This is the CVA is a revival statute. The only way my client's complaint or could have been untimely is if she filed the complaint outside of the window provided for those claims. And the defendant has only argued untimeliness. So it is improper for the defendant to bootstrap affirmative defenses of mental defect and infancy when he never moved to amend on that ground. I mean, this claim has been pressed not as if this has been a mistake, but it is the defendant's position that this is a timeliness issue. And I'd submit to the court that given the date of the filing of this complaint, it is impossible for this complaint to be untimely.
Well, he argues that you should have anticipated the defense.
The statute of limitations defense?
No, I guess infancy.
Well, first of all, the court doesn't even need to get to those defenses because under 3018B and 3211E, the defenses of infancy and mental defect were waived because they were not only not raised in the answer, but the defendant has expressly insisted to the lower court and to this court that he is only pressing a statute of limitations defense. You do not need to reach the merits based on the way counsel has strategized the case. This isn't a case where they realized their mistake after receiving our opposition, withdrew the motion, refiled it, and said, please give us leave to amend to add infancy and mental defect. This claim has been pressed and this strategy has been pursued, throughout the case, despite the awareness of our claims. With respect to the infancy claim, I'd submit to you that the lower court was correct in ruling that there's no bar against civil liability for acts committed as an infant, no matter what time period we're looking at. If you look at pre-1978, because the defendant has argued two different windows, right? Two different applications of the law, the court can look to Barker versus Kalish, where the Court of Appeals said that a defendant could not avoid civil liability and tort for acts committed as an infant and that were criminal acts. And if we're looking at this time window under current law, Rosen versus Schwartz, which is this court's precedent, holds that an infant can be civilly liable for torts. With respect to the mental defect claim, the claim was not based on any evidence. Now,
I think there was a doctor, right, who
yes.
put forth an opinion that the defendant was suffering from a mental disease or defect?
That's correct. Now, it should be pointed out that we were prejudiced by we would have been prejudiced had leave been granted because the defendant, was very concerned about waiving privilege at his deposition. Page 84 of the record, he disclosed the name of his current psychiatrist without waiving privilege. He extracted that concession from counsel. Had we been made aware that he was pursuing this claim, there would have been an IME. There would have been discovery of his medical records and mental health records, if any.
But the claim is that there's still a motion to strike the note of issue. Your note of issue is premature, though presumably all these issues then could be resolved if the note of issue is struck.
Well, this is, in my experience, this is interesting where a defendant seeks to strike the note of issue because the defendant hasn't submitted to his own attorney's questioning. Take note, counsel never served a notice to take the deposition of his own client. So this was, I see my time is almost up. Furthermore, and it's not disputed, the non-party witness testimony related to damages evidence. And the motion is still pending, but the non-party witnesses are being deposed. And in fact, my client accepted certain subpoena on behalf of certain non-party witnesses only for defendant to now file a motion to depose plaintiff's trial counsel to determine whether or not he engaged in improper behavior by accepting these subpoenas and serving them on the non-party witnesses. But that's beyond the scope here. With respect to the mental defect, if I just can have a few seconds here, Dr. Fornari did not establish his qualifications to proffer an opinion. There is no indication here whether he's ever practiced as a physician based upon his affirmation, and this is pages 209 to 214 of the record. He does not explain how he could have proffered an opinion without reviewing any medical records of Mr. Robb, current or dated. He does not explain his methodology for divining the psychiatric state and condition of Mr. Robb 50 years ago. He doesn't indicate whether he performed any test on him, whether or not it was necessary. He doesn't explain the details of his interview. He doesn't explain why he accepted everything that was told to him during this interview at face value, nor why he didn't seek to interview anyone else like the plaintiff in this case. With respect to his causation opinion, he concludes that because Mr. Robb was suffering from anxiety, depression, and PTSD, it somehow caused him to lack capacity to make decisions. And then at page 213, he asserts, again, without any tethering to any medical records or diagnostic tests, that this initiated changes in his brain and caused him to have retarded emotional development that prevented him to have capacity. Finally, he does not explain how, if Mr. Robb conceded twice, more than twice at his deposition, that he knew what he was doing was wrong when he was 8 years old, and he knew what he was doing when he was wrong when he was 15 years old, with his opinion that Mr. Robb did not, in fact, know what he was doing.
Question from Justice Moulton. Isn't it correct that these defenses, infancy and mental defect, relate only to a predicate to bringing your civil cause of action, not to the cause of action itself?
If I understand the question correctly, they are not a bar to bringing the CVA claim. They may be asserted as affirmative defenses, but there was no request for leave to amend.
Thank you.
Thank you.
If Your Honors, please, I'll follow up on Justice Moulton's two questions. Number one, I just want to point out that if the court looks at the interpretation of this legislation, you know, the legislature made a specific declaration, basically deliberating the decision to exclude from the CVA claims, you know, claims against those who couldn't be charged with a sexual offense. The legislature could have said, the legislation could have said, you know, regardless of whether it's an act of crime or not, they could have said that. And it makes sense under the circumstances because under the situation, the court was looking at a situation in which there were literally a cascade of claims caused by adults against innocent children. And these adults were in positions of authority. And we're talking about the clergy, the Boy Scout leaders, the coaches, the teachers, pediatricians. They weren't talking about children growing up in a dysfunctional family and having some bad interactions here.
I'm not understanding. So are you saying that it does not apply to this situation where you have an older biological brother who's abusing their younger biological sister?
Your Honor, that's exactly what I'm saying. I'm simply saying that it has to be criminal in nature. That's what the legislature was addressing. They were addressing.
And the actions, if true, that allegedly took place between the brother and the sister were not criminal?
That's right, Your Honor. If you look at the statute, specifically 130, you look at the penal law, and the language in the statute says, right, it says, suffered as a result of conduct which would constitute a sexual offense as defined in Article 130 of the penal law. An offense as defined even today in the penal law, Section 10, sub 1, talks about a conduct for which a criminal sentence of a term of imprisonment is provided. So the conduct must constitute a sexual offense that will be subject the defendant to criminal prosecution and punishment.
Sexual abuse is not a criminal offense?
Not when the perpetrator is under the age of 16. At the time, under Penal Law 2183, it was very specific. It had to be after 16 years of age.
Well, rape is a designated felony, is it not?
Today, Your Honor, today, we're talking about 1970s, 72.
Incest would not have counted either?
If you look at when the enumerating statutes came in for Section 301.2 of the Family Court Act, they defined all of these sections, and we talk about felony offenders and so forth. But even today, an exception, and so it's mutually exclusive. children under the age, and a crime. They say specifically on sub A that person subject to this is not criminally responsible for such conduct by reason of infancy. In other words, you cannot have infancy and crime. You cannot have it. It's in the statute, and the CVA didn't even address the whole family court issue of this because the court, I'm sure, is very much aware of what's going on with the family court and its jurisdiction. The cases that we've cited in our brief speak about the mutually exclusive jurisdiction. And in this case, since George was under the age of 16 at the time, he would not be criminally responsible under the circumstances. So the CVA is not triggered for those claims.
But I thought it was unclear as to whether he was 15 or 16, or whether his actions continued until he was 18.
It's not unclear at all, Your Honor. The argument is, before he was 16, he is underage, according to the penal law, according to the CVA. After he is 16, we have unrebutted opinion testimony submitted by Dr. Fornari that he did not have the mental capacity to understand his actions.
So it's interesting. So he admits to these acts prior to his being 16. He says, oh, yes, I did that. I didn't know it was wrong. So those cannot, your argument is we can't count those actions, but he denies any actions after 16, but he says, oh, I was suffering from mental disease or defect.
The mental disease and defect was occurring, according to Dr. Fornari, throughout this entire period, from the time that he was 8 years old.
Okay, and so your adversary points out the fact that Dr. Fornari really, what did he base his opinions on? Did he meet with him? Did he look at any records from
Yes.
when your client was 8 years old?
Yeah, number one, it's unrebutted. There's absolutely no proof but counsel's own affirmations to rebut the testimony of a physician that's submitted to the court. That's number one. So, I can't speak to that. What I can speak to is that Dr. Fornari, it's in his affidavit. He speaks about the records and the interviews with George at the time that this came up. Not when he was 8, but when this case was filed. Because there's no way to look back when he was 8, because at that time, no one knew about this.
So this is all based upon what
His
your
analysis-
client tells the
his analysis
doctor.
of the medical records of both the plaintiff and the defendant, his interviews with the defendant at the time, and his review of all the medical records.
All what medical records?
The medical records of both the defendant and the plaintiff.
What medical records of your client?
Well, both plaintiff and
When
defendant.
he was 8 years old, during this period prior to his reaching the age of 15, what medical records, what other records did the doctor examine?
Well, whatever medical records both the plaintiff and the defendant have, those were examined. It's in his affidavit what he exactly looked up. Both plaintiff and defendant have suffered horribly due to these circumstances. Horribly.
What I'm trying to get to, counsel, is exactly what did Dr. Fornari base his prognosis or his opinion on? Exactly what did he base it upon?
He based it on the medical records that were provided to him by defense counsel, which came from both the defendant and the plaintiff's counsel, who had in discovery given the medical records, some of the medical records for the plaintiff, looked over that, the testimony of the plaintiff, testimony of the defendant, and an interview.
How does the medical records of the plaintiff relate to your client's state of mind and whether he was in fact suffering from a mental disease or defect?
Well, Your Honor, I would submit to the court that that's irrelevant. He made a determination. He looked at these records, that's all. Whether it was relevant or not.
Of course
Your Honor, there's
his looking at records, they have to be relevant to his determination, to his final determination. So I asked what records he looked at. You said he looked at the medical records of the plaintiff.
And
so
defendant.
How does the medical records of the plaintiff lead to his conclusion that your client, who's the defendant, suffered from a mental disease or defect?
Your Honor, you asked what records he looked at. Those are the records he looked at. Whether he based his opinion on the plaintiff's medical records or the defendant is clear in his affidavit. He based them on the defendant's medical records. And what he looked at from the plaintiff's side of things was that the family abuse and the family scenario, dysfunctional as I name it, is throughout the medical records of both sides. So the testimony, the medical records from both parties were involved in the review.
So a dysfunctional family situation will therefore lead to your client, the defendant, suffering from mental disease or defect.
Your Honor, I cannot speak to that, and I would submit most respectfully, the court can't submit to that. We have a physician duly licensed in the state of New York, testifying and submitting an affidavit to this unrebutted. There
So
is
we don't, well, you say unrebutted, but I mean, we have to make a determination as to whether or not it is relevant and whether or not it should be considered, do we not?
Your Honor, absolutely. And you know why? Because that's why the summary judgment motion for the plaintiff should have been denied and our motion for leave should have been granted. If nothing else, it's an issue of fact. That's the point. The whole
Thank
point is.
you. Thank you both.
Thank you, Ron.
I don't believe you have any rebuttal, did you? So we will take a look at the briefs. We will review, as we always do, and we will make a determination. So again, thank you very much. Have a great day. Next matter up is Golubiowski versus Port Authority. Get out. I'm back in criminal court in the Bronx. She knows better than that. It's your fault. Okay, we're all going to behave now, yes? Thank you. Let me break my clock. Whenever you're ready.
Thank you, Your Honor. Good afternoon, Your Honors. May it please the court. My name is Richard E. Michel, and I represent the petitioner David Golubiowski. On this appeal, we have two primary issues, one having to deal with jurisdiction and the other having to do with the sufficiency of the arbitrator's award. And getting to the significant case of jurisdiction initially, we concede, of course, as we must, that under the statute, the wrong official person at the Port Authority responsible for receiving service was not served. However, we respectfully submit that the service that was performed was, looking at it objectively as we argue in our brief, that it was sufficient to apprise the respondent of the special proceeding.
So to accept that argument, we would essentially have to disregard the statute, correct?
Well, Your Honor, not disregard the statute so much as first identifying the statute, because we respectfully submit that the statute that Justice Rackauer went off on was the wrong statute, that this is not a 307 subdivision 2, that this is a 311 statute. And those are two very different statutes, because under the law as we understand it, and we've read it, and we point out in our reply brief, and I might add, I hope the court got this, we tried to submit or file a SEC order concerning, which is directed to the issue of jurisdiction. What we're trying to establish here is that the Port Authority under the statute is not a state agency. It may be a municipal corporate instrumentality as it's referred to in the SEC order. It may be a body corporate or politic as it's referred to in Section 6404 of the Unconsolidated Laws. But most assuredly, Your Honors, it is not a state agency within the meaning of 307 subdivision 2. And if we are in agreement about that, then the analysis insofar as jurisdiction becomes somewhat different. Because if you look at the facts of the case, in this particular instance, the person who was designated to receive service, while it was the inappropriate person, was the only logical person who could be identified as the person to receive process. And we
Why
go
is
through.
that? Because
Pardon?
why do you say that? Is that because this individual was the attorney who was present at the arbitration?
Not just the attorney who was present at the arbitration. This was the person who was the most intimately involved with this case for over a year. She prosecuted this case And she was the one who filed the closing arguments to the arbitrator and argued the case.
That's all well and good, but why would that lead one to believe that she was the individual who would be designated to accept service?
Because under the statute, Your Honor, most respectfully, it says a designated person or somebody who would be designated by that person to receive process. And unfortunately, the statute is unclear as to who it was who was supposed to receive.
I'm sorry, which statute are you referring to, 307
Well,
or
it was,
311?
I believe it was 7502.
7502.
And the fact of the matter also is that the identities of the persons who were to be served and their locations were almost identical. The only difference between them was the floor in the building that the notice was sent to was, I believe, the 25th floor instead of the 23rd floor.
Counsel, how do you address the fact that the website clearly gives notice that service should be made upon an officer?
Yeah, but the statute also says,
No, but I'd like you to answer my question, because the website says you should serve the officer. So can you address that?
All I can say is the wrong person. Your Honor, you're absolutely right. But in reading the statute, as the statute was read, before even getting to the website, it says, or a person designated by that officer. And in terms of identifying a person who would be designated by that officer, an inference to be drawn, would have been the person who was not only an employee at Port Authority, not only an attorney at Port Authority, but the one person who had complete control over this case for at least a year until its finality.
So 3072 is what you're referring to, yes?
I'm saying that 311...
Is that what you're referring to, 3072?
No, I'm saying that's the wrong statute.
So you're stating what statute applies?
311. And I might add, Your Honor, there is not one case in this jurisdiction, not one case that identifies the Port Authority for the purposes of service as a state agency. If we get beyond that, then our argument becomes one of an equitable argument, and we do make jurisdiction.
Counsel, I just have another question. So what evidence was there that the attorney was the designee to accept service? Was there any, inquiry made as to whether that person was designated to receive service?
Evidently not. And what had happened was that if you look in the notice of motion, there is more than a month given to respond to the motion. And it is served overnight mail, and the record is clear that up until almost the time that this motion was returnable in Supreme Court, nothing was said one way or the other, except for a telephone call to extend the time to put in an answer. Nobody at that point suggested that there was anything wrong with service.
So, counsel, I want to be clear. You're conceding that both under 311 and under 307, this individual was not the proper individual to be served, right? Because she wasn't designated.
That's correct.
So you're saying that you're out of the water on 311, you're out of the water on 307, so therefore we should look to some type of equitable determination.
As this court, well, what I'm saying is that the more difficult statute to get around with equitable considerations would be 307. I'm saying that this falls squarely within 311, and this court has recognized equitable considerations in terms of forgiving that defect. The Court of Appeals has forgiven a defect in the service. There is no question that the Port Authority was served with process, and they fully understood what the nature of the proceeding was. There's no question about any of that. The question was the actual person who received it. That's the only issue on that.
Do you have a question? No? Thank you, counsel. You have time on rebuttal.
Yeah, I would like to address the other issues on rebuttal with the court's
Most definitely.
permission. Okay, Thank you.
Good afternoon, Your Honors. Paulo C. Alves, Port Authority Law Department, for Respondent, Port
So,
Authority.
counsel, how does this fall within 307?
Well, the Port Authority is a bi-state agency that's created by compact by two sovereign states, New York and New Jersey, and is approved by another sovereign, the ultimate sovereign, the United States
No,
Congress.
I understand you're making an argument, but what are the cases, do you have case support that 307 is the right statute for service as opposed to 311?
There are no cases that actually say that, but we're dealing with an entity here that is a public entity, is a state agency, a bi-state agency, but
Well, why
more
wouldn't
importantly,
311 apply then? Why couldn't we just as well apply 311 to that?
because 311, actually, if we look at 311, there are various types of entities that are addressed in 311. I believe the one that the petitioner is trying to fall under is the private corporation portion of it, which the Port Authority, I don't think by any definition, can be. The Port Authority, just to, by way of analogy, with my previous classification as a bi-state agency, is actually cloaked in sovereign immunity and has consented to suits. So there's nothing private about that. Now, 311 also has other entities that are delineated, political subdivisions, which the Port Authority clearly doesn't fall under as well because they're clearly defined. For example, sewer districts, park districts, cities, counties, things like that. But even in the scheme of 311, we can see that there's quite a bit of leniency as to who could be served under the first portion of 311, which is the private corporation. And then it's not as lenient when you get to the political subdivisions. There are particular people, or officers, I should say, that need to be served in each of those political subdivisions. Now, the argument here that is not, well, it's
Well,
clear
the
that
argument is you have notice, that you're on notice, you know what it's about, you assert, and you're able to file an answer and also assert a jurisdictional defense. Why shouldn't we overlook it and at least hear the merits?
this court shouldn't overlook it because all of the cases cited to by petitioner and through my research as well, the court overlooks under 311, we should say like a technically improper service when there is a genuine indicia of due diligence to comply with the statute. In all of those cases, there was, for example, personal delivery. Sometimes, in one of the cases, for
But here there was delivery to counsel. I mean, you cannot dispute actual notice.
Your Honor, I didn't hear your question.
Here there was service upon counsel, and you cannot dispute that there was actual notice. Clearly, the service was incorrect, but there was actual notice.
There was actual notice to the extent that we had noticed that there was an action filed, and then at the first opportunity before the court, as we were entitled to do, we asserted our rights and moved to dismiss on the ground that we were entitled to move under. And that being a jurisdictional ground, in part at least. We obviously moved to dismiss on the merits as well.
But counsel, you made reference a little while ago to the lack of due diligence, or at least in those cases that you looked at, that there was some type of requirement of due diligence. Why would that have been necessary here where the individual who was served, as your adversary noted, was the individual who took part in the arbitration hearing, the individual who made the arguments? It would appear, therefore, that the petitioner knew who the individual was or had an idea as to the proper person to serve.
I respectfully disagree with the characterization that the petitioner knew there was a proper person to serve.
You're correct. That would, I mean, perhaps would, it would not be an unreasonable assumption on the part of the petitioner given the involvement of the attorney in the proceedings.
I would characterize that as the easiest person to serve without looking at the website, which tells you the actual person to serve. In addition to that, aside from the identity of the person, the manner of service was not followed in either of these service
It was overnight delivery, right?
Only, yes.
Yes.
Correct. There was no attempt at personal service. There was no attempt to figure out who the actual person was. So we have a question of manner and identity. And the Port Authority moved to dismiss based on personal jurisdiction on the violation of specifically 307, but frankly, it would also be a violation of 311.
Are you suggesting that, that we don't have the authority to overlook a defect, especially under circumstances where you are on actual notice of the petition?
To say you don't have the authority, I think is a little far for me to say, but under the
Well, I
case
mean,
law,
under the
it
case
wouldn't
law.
fit.
Under the case law.
Under the case law, no, because under the case law, the courts look to what actually happened. And what actually happened was there was an attempt to comply with the statute. Here, from the get-go, there was a complete ignoring of the statute and putting something as if it was a discovery response or a deficiency letter in the mail or in a FedEx box and sending it out. As an attorney, I know that when I need to serve someone to start an action, to bring someone, or in this case, a public entity, into court, I need to look at the statute and figure out which one, even if it's confusing. And in that confusion, I might pick the wrong one, but at least try. At least try, and that did not happen here.
Thank you.
What I really wanted to address, excuse me, was what the arbitrator did in the case if we get past the jurisdiction. But one thing that I have to point out is that counsel takes issue with the way we delivered by using FedEx. Whether he agrees with it or not, or the court today looking at it agrees with it or not, we were relying on a 1996 case out of this court, the Colucci case, which permitted it. Now, I know that decision has been questioned, but until this court overrules that, I think that as a litigant, I'm entitled to be able to rely on that case, however misguided that case may be, or counsel thinks that case may be. But if I may address what the arbitrator did in this case.
I'm sorry, so this was in 2017?
Pardon?
The petition was filed when, in 2017?
I'm sorry, which petition?
The petition, you're saying that you served based upon a 1996 case?
We served.
Overnight, based
Right.
upon a 1996 case?
From this court, Colucci.
From this court in 1996, but this was in 2017 that you did this?
2018.
2018.
Right.
We haven't rendered anything or said anything concerning
No.
service since then?
Quite frankly, Your Honor, the case has never been cited. My research was the case has never been criticized by an intermediate appellate court or a superior appellate court. There was one court, an inferior court, which questioned the wisdom or the validity of it, but that's not binding on this court.
It's interesting you did the research in terms of the cases, but you didn't do the research in terms of proper service. But please, continue as to the arbitration.
All right. Our burden here, assuming we get past jurisdiction, is to establish almost irrationality. And here is the
Well, actually, before we, what is the scope of our review? Is it we look at it as an arbitration agreement or as an Article 78 substantial evidence?
I'm sorry, Your Honor.
What is the scope of our review? Article 78 review, or is it we look at it arbitration?
It's voluntary arbitration. This is not compulsory arbitration. And as I understand it, the standard is almost irrationality. And I must...
Violative of public policy, in other words.
And violation of public policy. And frankly, as I read some of the cases where it's been compulsory arbitration and voluntary arbitration, these terms are used interchangeably. I can't define them for you. I don't know if my counsel, my adversary can define them, but here's what I'm saying to you. In terms of how this case was prosecuted, they insist that this is a civil case, but yet this case was prosecuted as though it was a criminal case. And the prosecutor in this case, a former assistant district attorney, the whole centerpiece of her case was that my client committed bribery, that he allowed himself to be bribed. And as we point out in the brief, There was no bribery in this case, but yet, of course, the arbitrator is being told it was an it was a bribery.
Your client didn't receive money?
That's not bribery.
He didn't,
Your Honor,
hold on a second. He
Your Honor,
didn't-
most
Counsel,
respect.
Counsel,
hold on,
just one
hold on.
second.
Hold on. He didn't discuss use of personal computers, that he was going to check for criminal records. None of that happened?
That whole conversation happened, but
So,
can I?
isn't that sufficient?
I'm sorry?
Isn't that sufficient? He's been giving money to make these checks that others would not be allowed to.
Can I explain? Can I respond to that, Your Honor?
Briefly, go ahead.
Okay. This taped conversation, you know, was generated by a confidential informant who was working cases, who was trying to work his own case off, and the target of the investigation was my client's father. And he's brought into a luncheon, and they're sitting there for an hour and a half, and this conversation going back and forth and back and forth. And this was such an inconsequential conversation involving my client that at the very end, almost as an act of desperation, this confidential source, looking to work cases off, shoves money at him, and my client, according to the testimony, says, I can't take this. And the guy shrugs it off, walks out, and my client gives it back to his father and says, give it to the confidential source. I can't take it. Now, in their investigation, this is how consequential this conversation was. In their two law enforcement agencies, Your Honor, DEA and ICE, are looking into my client's misconduct. They have no information before this May 23rd luncheon, and they have no information after this May 23rd luncheon that my client is criminally involved in anything. And what happens is, 2 weeks after this meeting, they close down the whole thing, and that's the end of story. They tried to trace the traffic-directed funds to my client. They couldn't trace them anywhere. Case closed. All of the prosecutors in the case declined prosecution. There was no place to go. The only person in this jurisdiction who thought anything of that conversation, that it was consequential, was the arbitrator. We're saying that's irrational, Your Honor. We respectfully submit. And on top of that, the whole centerpiece of this was the idea that my client accepted a bribe. There was no agreement, there was no proposal, there was no understanding. It was just shoving the money. But this prosecutor, a Manhattan DA, tells the arbitrator that this is bribery. It is not bribery. And my client now sat for 10 years on administrative suspension at a desk doing his job every day of the week. 2 people from the Port Authority come in and testify what a great employee he is. 10 years, and the former assistant district attorney is telling everybody that my client is a briber. Nonsense. And then at the end of it, where there's no other evidence other than this tape, this inconsequential tape that goes nowhere for anybody, my client winds up terminated. Under these circumstances, Your Honor, I respectfully submit that while deference is always paid to the arbitrator, it wasn't deserved in this case.
Thank you so much, counsel. Thank you so much. Thank you both. Chaudhry versus Phillips. You asked the question. I don't understand why you did that.
Got it down. Good pronunciation.
Thank you. Is it all right?
I'm sorry.
Oh, no problem.
I apologize.
Good afternoon, Your Honors, and may it please the Court. Amy McCampbell on behalf of the appellants. Your Honors, Supreme Court should have granted summary judgment here, and we ask this Court to reverse and grant summary judgment. Plaintiffs' claims fail as a matter of law on multiple grounds. So starting with plaintiffs' roadway maintenance claims. Plaintiffs' pothole claim. The city is entitled to summary judgment on the pothole claim for 2 main reasons.
Can you focus on the design claim?
Sure, Your Honor.
That's the crux of this case.
So with the roadway design claim, the Court of Appeals in Brown versus State of New York clarified what the standard is in 2018. The plaintiff has to show that the defendant was made aware of a dangerous condition.
And is there anything in the record to suggest that you were on notice of the dangerous condition of the roadway, essentially lack of a breakdown lane?
That's exactly the question, Your Honor. And for the vast majority of the alleged defects that plaintiff is challenging here, there's absolutely nothing anywhere close to showing any notice. So with respect to the gore, the weave, the signage, the call boxes, there's no record of any prior accidents connected to any of those features, nor is there any showing that they violated any mandatory safety standards.
How about the lack of a breakdown lane?
Sure, Your Honor. So with the lack of the shoulders, the plaintiffs have pointed to scattered incidents on this highway that have been associated with lack of shoulders, but we're talking about 12 accidents over a 20-block span over a 10-year.
So wouldn't one accident be enough to put you on notice, especially where someone dies as a result of being struck on a roadway without a breakdown lane or a shoulder?
Well, Your Honor, two things in response to that. There's dicta from Gregorio that indicates that, but we haven't found a single case that has reached such an extreme holding, nor have plaintiffs. And we cited multiple cases in which courts have found that when there are a number of scattered accidents over a period of several years, that's not enough to show constructive notice. Second, the only fatal accident that we have in the record associated with lack of shoulders is the Asa accident.
Yeah, December 1987.
Is that the gentleman who was changing a tire?
Well, he was struck and killed by a hit-and-run driver, Your Honor. We don't know much about the accident, but it did occur in a section of the highway that did have turnouts. So it's not, the section of the highway, the 20-block stretch, roughly 20-block stretch, without shoulders or turnouts is north of 162nd Street. And the Asa accident, as we've explained in our papers, occurred in the southern area where there are intermittent turnouts. So to say that that was caused by a lack of any turnouts.
But it's the same highway, is it not? It's the same highway. It's the Harlem River Drive, right?
Yes, Your Honor. The Harlem River Drive, it's quite a long highway, and the top 20 blocks or so is the section that does not have any shoulders or turnouts. And that is the section where we have only 12 examples of accidents over a 10-year.
So it goes back to my first question. 100 accidents, 200 accidents? I mean, what's the number that'll put the city on notice that something needed to be done on that highway?
Well, we see some examples in the case law, Your Honor. Patty was one accident was not enough. Fan Guang is similar to this case. It was 11 similar collisions over 10 years on a heavily trafficked highway. The court says that's not enough to show notice. Benjamin was a case where we had 2 prior accidents in 5 years, not enough to show notice.
So here we have 12 over what span?
It was about 10 years, Your Honor. The Department of Transportation searched its records for 10 years prior to the accident, and also we have references to accidents in several consultant reports. And all of those occurred in the 10-year span. We have 12 accidents occurring on this stretch of the highway.
And I'm sorry, how many people died? Only one person died in those 12 accidents?
As far as we know, Your Honor, the Asa accident was the only fatal one, and again, that was the one that was in the area with turnouts. One of the consultants' reports, the TAMS report, which plaintiffs cite to from 1995, the TAMS report pointed out that there were a series of accidents associated with lack of shoulders in the stretch of the road, but the TAMS report also said that this rate of accidents over this long time period, over these several years, was not enough to indicate a problem that needed to be addressed. So the city had no notice that there's any design flaw with this area of the highway. If I may, in my last few minutes, I'll just address the roadway maintenance claims. The pothole claim, plaintiffs have failed to show that the city had prior notice of any pothole that caused the accident. In fact, there's no indication that there was any pothole that caused the accident, and therefore plaintiffs have failed to establish a prima facie case. With respect to the lighting claim, there's also no indication that a lack of lighting caused the accident, where Phillips' testimony was he was looking over his shoulder rather than up the road and didn't see Chowdhury until it was too late. Moreover, plaintiffs have not addressed the Thompson versus State of New York case, which the Court of Appeals clarified that in order to prevail on a lighting claim, the plaintiff must show that the defendant had a duty to provide lighting at that area. And plaintiffs have not shown that or haven't even argued as much. So plaintiffs' roadway maintenance claims definitely fail as a matter of law. And
on the roadway maintenance, in terms of the shoulders and the lack of any shoulders, were any studies done in terms of whether there should be shoulders or there should not be any shoulders?
Well, Your Honor, That's really a government immunity question, whether we looked at the problem and.
But you don't have,
And we
you
can't,
have no.
exactly, we can't argue government immunity because it wasn't pled.
You're right.
That being said, Your Honor, again, the TAMS report in the record does address the accident rate, and it addresses the accidents associated with shoulders, and says that there is no need to do anything further on this stretch
So
of the
there
road.
was no recommendation that that there should be shoulders or there should not be shoulders?
The TAMS report did not recommend any changes to the road based on this accident rate. There was another report from Honesty in Hanover that recommended that shoulders be placed on certain stretches of the road, but not this northbound section, Your Honor.
Thank you.
Your Honors.
May it please the court, my name is Laura Gentile. It is my honor to represent the family of Zamil Chowdhury, his wife Jasmine, and his two children, Fahima, who was 2 years old, and Fahiba, who was
So,
1.
counsel, I'm just curious, why is it taking so long for this case to proceed? This accident occurred in 1994.
Yes, Your Honor. I got involved in this case on appeal after Judge Stallman dismissed the case initially because neither side appeared for what was then called the clerk's calendar call. And I appeared before.
So there has not been any, obviously there has not been any determination on the merits, right?
No, not at all.
And that appeal was because of a dismissal?
There was a clerk calendar call dismissal. Since then, we've had a bankruptcy, which stalled the case for years. We had the death of the defendant, and plaintiff's office spent quite a bit of time trying to get because this is what we have to do, trying to get one of the relatives, his daughter, to become administrator so we could continue. And ultimately, we had to go to the public administrator.
Okay, thank you. I was just curious.
Yes.
Thank you very much.
This is, I imagine it may be one of the oldest cases on the docket.
Counsel,
It's certainly my oldest case.
I'm sorry, can you address your adversary's point that while there have been prior accidents here, it's not sufficient to put them on notice?
If I can, Your Honor, I'd like to step back to fundamental principles because the risk reasonably perceived defines the duty to be obeyed. Halsgraf, right? Judge Cardozo. So I think that the issue is, was there a risk reasonably perceived here or should have been perceived? And there are numerous sources for that, including...
Is one of those sources the TAMS report?
I'm sorry, I'm having...
It's one of those sources, the TAMS report.
Absolutely. The TAMS report specifically criticizes the absence of shoulders and turnouts and directs that they should be included. The TAMS report, the Hardesty report also does that. We have other sources. We have the decision of this court in Toyos that has very direct language that says the absence of shoulders directly caused this accident. And they also referred to the Hennessy report. I disagree with the defense counsel about where the OSA accident happened. The OSA accident happened 100 feet south of where the weave begins, 1,000 feet south of where the spot where Mr. Chowdhury died, very close. And that was a death case. And I disagree when defense counsel indicates that there was turnout at that location. There were not turnouts at that location because, and the record, I asked the court to look at the police report to understand where that accident happened. It happened very close to the Chowdhury accident, and it happened because there were no shoulders or turnouts in that location. We have John Armstrong, who was a maintenance supervisor, who for every week, several times a week, for 4 years, up to the moment of the accident, drove his car, parked on that gore, and said whenever he had to get out of the car, he took his life in his hands. He hoped he would live to see it happen, that he would get back in the car. He told his borough supervisor, and he told the deputy commissioner who was responsible for this. So these are all people who knew how dangerous this location was. We haven't even gotten into the weave, where the city created a condition that there's not enough room for Mr. Phillips to weave across several lanes as required. So we have that the city created the condition, the city had actual notice of the condition, and they had constructive notice of the condition.
So, Council, could you address the issue as to the potholes?
Sure. We have, and I have the page numbers. Between 2407 and 2461 of the brief, we have all the notices of claim, putting the city on notice.
In this instance, it seems to me that before that even becomes an issue, you have to show, or at least raise an issue, that the car hit a pothole which blew the tire out.
Okay, so potholes versus lighting. We're talking about potholes now because I think lighting is well established. The duty issue was raised for the first time in reply, and this is an intersection, if there ever was one anywhere in the city of New York that required lighting, this was it. On potholes, the evidence is limited. The city.
Well, forget evidence. Is there any evidence to suggest?
The evidence is he had a blowout.
So,
Nobody,
well, why do we assume that that hit a pothole?
because that is the most likely
Sounds speculative.
source.
Sounds speculative, doesn't it?
I would not say that, Judge.
Okay.
I would say.
So why don't you address the lighting? Address the lighting.
I beg your pardon?
Address the lighting issue.
So the lighting issue, there certainly is a duty. It was never raised in any procedurally appropriate time, but the driver, Phillips, said he couldn't see. The police officer said that there was a light out.
Notice?
There's first of all, you don't have the administrative code requirement of prior written notice, but all of the numerous of the notices of claim in the page numbers that I cited say it's dark, it's pitch black here. It's extremely dark, and the motorists were complaining about that. The notice comes from the notices of claim. That's what we have on notice, Your Honor.
Thank you.
I rest on my brief.
Your Honors, I'd like to just correct a few points here. There's nothing in the record of any consultant report recommending shoulders at this location. The TAMS report from 1990.
Council, I was thinking, do we only look at the number of accidents and fatalities at this turnout, or the fact that there's a lack of turnout here or shoulders here? Or do we look at we look at the entire highway to see the number of fatalities and accidents where there are no shoulders or no turnouts?
Well, the highway conditions vary throughout the highway, and as our expert Lionel Noel pointed out here, this location would be a particularly inappropriate place to place a shoulder or turnout because it is so complex. And for that reason, that distinguishes this case from the Toyos case, which was a flat straightaway, in which...
So if there's a determination that there should have been turnouts or there should have been a shoulder, then we just continue with the roadway in its current condition without constructing the turnouts or shoulders?
I'm sorry, I don't quite...
I'm saying if there is a determination that there should have been a turnout or there should be a shoulder at this location, do we just continue with the roadway in its current condition without the shoulders and the turnouts?
You know, I think that would be the decision for the Department of Transportation to decide what is the best way to address the highway here.
No, because you just said that it would be too complex, that the complexity of the roadway at this area, lends itself to not having a shoulder.
That was the testimony from the city's engineer here, Your Honor, and that was why this location would be a particularly inappropriate place to place a shoulder or turnout. And again, there's nothing in the record to show that any consultant ever recommended shoulder turnouts at this location. Page 2687 of the record is a map showing where shoulders were recommended. It's not this stretch of the highway. Page 3118 of the TAMS report talks about the accident rate related to shoulders, and it says that accident data suggests there would not be a benefit from addressing the substandard shoulder width. So there was no recommendation made to the city. I see I'm out of time, Your Honor.
You can finish your thought.
I just also briefly want to address the ASA accident. Plaintiffs argue that it was close to this accident location, but they provide no reason to believe, to justify their belief on that point. As we've explained, the police report, 2389 of the record, says that this accident occurred south of the Harlem River driveway, which was a term that was used to refer to the drive north of 155th Street. And for that reason, we know that it occurred in that portion where there were shoulders and turnouts.
Thank you.
Thank you.
Fernandez versus Mercy First.
May it please the court. My name is David Rutherford, and I represent Mercy First in this appeal. This is a case about duty, and the duty question that we face in this case is whether a non-secure residential treatment facility, like Mercy First, has a duty to prevent a resident from leaving its facility.
Well, what steps did you do or take to stop the resident from leaving? Because it's only acts of persuasion, correct?
That's all we have.
That's right, but did the employee, for example, ever attempt to intervene to prevent the child from leaving the GEMS facility?
Well, numerous...
Rhetorical question.
Numerous employees did do that, but if you're...
I'm talking specifically when the child disappeared.
When the child absconded from the program?
Correct.
Didn't have an opportunity because the
Because she was looking for parking?
I'm sorry?
Because she was looking for parking?
No, she wasn't looking for parking. She parked the vehicle and she was looking at the front of the facility to see when she
She didn't
came
take
out.
15 to 20 minutes to find parking before she began her look?
Well, of course. I mean, it's in Harlem and it's on a one-way street with a lack of parking. So we take her there and then we have to park the vehicle and then we wait for her to come out. Much like anyone else would drop someone off at a facility. So when she goes in the facility, she's in the care of co-defendant GEMS, and that's where we thought she was. But in terms of, let's say that she saw her come out, she has no way to physically restrain her.
Well,
All
but
she can
she
do
could have,
is-
under those circumstances, she could have exercised or attempted to persuade the child not to leave the facility, and maybe then you have an argument, as in the third department case, look, we did what we could, it's non-secure facility, we attempted and she left. But that's not what happened, correct?
Well, that's not what happened in those circumstances. But someone who is bent on leaving and who intentionally lies and intentionally tries to create an opportunity can always find that opportunity to leave. For instance, the week before that, she was home with her mother and went out and found her pimp and spent the night making money for him. So if it wasn't that she did... That
But really, this case, what you're arguing now is causation. I mean, that's what it sounds like.
No, I'm talking duty. Well, we don't get to causation because there's no duty to prevent them from leaving. And so your question
But no,
is...
I'm sorry, counsel, don't you have a duty, essentially a duty of a reasonable parent here?
No, I don't believe that. The cases that talk about the duty of a reasonable parent are school cases. And the reason for that is that you were in the physical custody of the school at that time. But as soon as the resident leaves the physical, or the student leaves the custody of the school, the duty ends. And so if you want to talk about the school cases and reasonable parent, the duty ended when she absconded from the program. And at that point, she hadn't been injured yet because she left. It's not until she took the train to Connecticut and then started working for her pimp again that she was injured. But she had already left the program from that time.
So I'm sorry, counsel, I do not understand. So do you have a duty, yes or no?
Duty to what?
Duty to protect, duty to prevent her from absconding, duty to ensure that she is safe.
Absolutely do not have a duty to prevent her from absconding.
Do you have a duty to ensure that she is safe?
When she is in our physical custody.
Okay, so again, when she's dropped off at GEMS, right? Your argument is once she leaves the vehicle and is no longer in the vehicle or under the, I guess, the control of the employee, your duty, any duty that you had ended?
When she enters the GEMS facility,
Yes.
she is under the custody, care, and control of GEMS at that.
So in other words, your employee, under your argument, could have just left.
No,
Premises.
because we've brought her there, and we have the duty, once she leaves and comes back to us, to bring her back to our facility where she's a resident.
But you have no duty to ensure that she actually comes back to your, I want to say custody, to your care.
That's what that's what I'm arguing as our central point, is I think what your honors are talking about is breach and proximate cause. But I say you don't even get to that because you don't get beyond duty. And the duty is, if this is a voluntary program with no security, no walls, no way to physically restrain someone, if she decides to walk off, that's her right. We can't prevent that.
So that's what I'm trying to determine, the parameters of your duty. That's what I do not understand. I'm trying to figure out exactly what are the parameters of your duty.
Okay, the parameters of our duty is if she wants to participate in the program, and she's participating in the program, then we have a duty to keep her safe. If she decides to leave the program, we cannot prevent her from leaving the program. That's where the duty ends.
But counsel, you took action in this case to prevent her from leaving, right? So there was a period in time where you didn't deliver her to GEMS for the fear that she may abscond.
Well,
You must have thought you had some duty.
what we're trying to do is dissuade her somehow. So when we put her on one-on-one supervision, or when we say we're not going to take you to GEMS, we're trying to make it more difficult for her to leave. But she could have walked off the campus at that point. If we said we're not taking you to GEMS, she could have just left.
So if she decides to just walk off the campus, is it your position that you don't have to do anything? You don't have to speak to her. You don't have to try to convince her otherwise. You just let her walk.
I don't have a duty to prevent her from leaving.
But you have a duty to intervene and to as the employee testified in the EBT, a duty to talk to the child, to try to convince her that it would be more appropriate to stay in the facility, and then the child does what the child does, correct?
Verbal persuasion.
That's a duty. And that did not occur in this instance because your employee, for whatever reason, did not see the child leave the GEMS facility.
We did not see her leave, so we did not have an opportunity to exercise verbal persuasion. But
so that suggests to me that there is a duty, and what we're talking about is breach and causation.
no, that's not. You're talking about preventing. First of all, she goes to these programs, she goes home on the weekends. There's plenty of times where she just leaves, okay? And here is an instance where she just left. She didn't give us the opportunity to try and verbally dissuade her.
But you didn't one reason was because the employee did not actually see her, did not keep her within her eyesight to determine whether she left GEMS or not.
She couldn't keep her within her eyesight because she was in the building. For all we know, she went out the back door. If she wanted to leave, she could have left at any time.
Question from Justice Moulton. So therefore, there's no duty to dissuade a vulnerable person from leaving the program?
There's no duty to prevent her from leaving the program.
Or dissuade a vulnerable person from leaving the program?
No, because it's a voluntary program.
So if she were to say, I'm going to go out and commit suicide, you have no duty to dissuade her from doing so?
That's a different issue.
Well, I mean, if she says, I'm going to go with my pimp and I'm going to continue to be lent out to men throughout the state and throughout the Northeast or what have you, to some extent, that's almost suicide. So again, you have no duty to dissuade her from going back to sex trafficking.
No, those are two different issues. Number one, this population, that's what they deal with. That's what they struggle with, which is whether they're
all I'm asking is, again, follow-up, is there a duty to dissuade her from leaving the program and engaging in that activity?
No, there isn't. But I would like to answer the question you asked, which is suicide or something like that. In an instance, and this is clear in the testimony in the record, where there's a danger of self-harm or harm to others, physical harm, then, and only then, can we use
So
physical
a child being
restraint.
trafficked is not maybe self-harm?
It's not suicidal.
It's not self-harm?
It's not homicidal. And those physical restraints, as the record makes clear, can only take place on the premises. Once they're off the premises, we are not allowed to use physical restraints.
Thank you. You have time to rebuttal.
Good afternoon, Your Honors.
So, counsel, I mean, it is clear, this is a non-secure residential facility where their only means of counseling, I guess, is, verbal cues, one-on-one counseling, et cetera. And your adversary makes the point that, there's no duty to ensure that she stay there, that she not abscond, and they can't prevent her from doing so.
Your Honor, that's not correct, and a lot of what counsel said, and I'd like to spend some time detailing how the testimony in the record is different than what counsel just argued. The testimony is quite clear that the Mercy First employees, and this was not a voluntary program, this was a court-ordered program, they've conceded, they've argued that the standard of care here is the Moran standard, the reasonably prudent parent. They had a duty, the record, their own testimony, they had a duty to supervise this young girl, a vulnerable girl, 24/7. All right, they had a duty to supervise her, and that included, it didn't.
Counsel, but that's not accurate, because she goes home on weekends.
No, she's being supervised by her parent at that. That's a supervised visit. She didn't just walk out. The record's quite clear, pursuant to court order and the rules of Mercy, she was allowed to leave being supervised by her parent. So she didn't just walk out. She's not allowed to just walk out. The record's quite clear, they're not allowed to just leave. And the record's also quite clear that when she walked into GEMS, the Mercy First employees, Danae Diggs specifically here, had an obligation to still supervise.
Well, why was she not then in GEMS, quote-unquote, custody at that point in time? She's in this GEMS building.
GEMS it's just a program. They don't have a duty. It's totally different. This is a court-ordered, Mercy First is a court-ordered program. They have physical custody, and the record's quite clear. They have the duty to supervise 24/7 the plaintiff here, not GEMS. And that's why they sent somebody. The record's quite clear that people at Mercy First are not allowed to leave the premises unless they're being supervised. That was the case here. They sent a woman, Danae Diggs, to drive my client to GEMS to watch her. We then get into the issue of negligence, and there's an issue of fact, and it's quite clear, and I just want to bring something up because we've been talking about verbal cues, again, which wasn't done. She could have and should have, and the testimony is she was supposed to, she could have called the police. She could have followed the plaintiff when she left to know where she was so that the police,
But
they had an obligation under the law to do that.
The day before this incident, or a couple of days before this incident, I thought the record stated that plaintiff had actually told the counselors or whomever that, she had thought about leaving and going back, but she decided against it.
Your Honor, I think that totally helps our argument. 6 days before this incident happened, she is on a one-on-one supervision. Mercy First is telling GEMS she can't come because we're concerned about her safety. She's told us, and we're concerned she is going to go AWOL and get back into the life. 3 days later, or 4 days later, she is all of a sudden better. She's stable. And she's sent to GEMS. They knew, and they instructed Ms. Diggs, keep a close eye on her. Ms. Diggs knew about these issues, and she let her down that day. She didn't watch. And one thing I'd like to bring up, Justice Singh, I believe you brought up the fact as far as a physical intervention. And the record is also quite clear that under the circumstance where, again, the plaintiff here, if she posed a danger to herself, that would be a situation where you could put on this therapeutic hold, a physical intervention. And I believe that's an issue that should be presented to a jury beyond the verbal cues, beyond calling the police, beyond following her. If you know that, and it's foreseeable that she said it, and she's going to go back into a life where she's being trafficked and horrible, horrible things are about to happen to her, that poses a danger to her. And that's a situation where I think a physical intervention would be warranted.
You want to address causation?
Sure, Your Honor. Yes, it was certainly foreseeable, again, that if they didn't properly supervise the plaintiff on this day, that she was going to do what she said she was going to do, abscond. She was going to go back to the life that she had. It was foreseeable. And as far as proximate cause, and they've also argued intervening cause, those are issues of fact. It was certainly that their negligence, that, again, it was foreseeable that she might end up happening. And, again, these are issues of fact for a jury to decide. Just because a criminal act happened by her pimp, that's been recognized, the court's recognized. Again, there still could be, again, a proximate cause, and it's not necessarily an intervening cause.
Thank you.
Thank you.
Just a couple of quick points, Your Honor. First of all, physical restraint can never be used off the premises. And the record's clear. I'll give you the cites.
But why does it even matter? I mean, because in this point, no restraint, no intervention was ever exercised by Ms. Diggs. I mean, that's the issue. I understand you say there's no duty when she's at GEMS, but if we were to find that there was a continuing duty, didn't Ms. GEMS have a duty to be vigilant, watch the door, putting aside the issue of whether she could be in the facility or not?
That's breach. That you're arguing breach, and I'm saying duty. And I'd just like to direct, we cited this case in the brief, the Mayorga case by the 3rd Department, which is remarkably similar to this case.
Okay, how is Mayorga similar to this case?
Because you had a juvenile detention facility that could not use physical restraints unless it was immediate danger, like suicide or homicide.
And would you agree in that case that the juvenile was already out of the facility, one, and two, that when the juvenile attempted to leave the facility, there was an attempt at an intervention by one of the counselors? Right, but does that, I'm sorry, so do those facts distinguish it from our facts?
No, because you could only use verbal persuasion in that case, just like this case.
And what verbal persuasion did Ms. Diggs use?
She didn't get the opportunity. But the point I'm trying to make is, in the Mayorga case, the holding is this. We agree that defendants established as a matter of law that it owes no duty to the plaintiff to prevent the resident from leaving its facility, and thus has no liability to the plaintiff.
I thought in that case, the plaintiff, the child had been discharged from the program.
No.
Mayorga.
No, he left. He ran. And then because he was gone, he was deemed discharged. And because of that,
yes, he was deemed discharged. He was no longer a part of the program. He had permanently left the defendant's premises and been discharged from the program. At the point where the employee dropped her off at GEMS, she was still a resident of Mercy First, and therefore still within the supervision of Mercy First.
what I'm saying is the holding is that you have no duty to prevent someone from leaving the program. And that's the crux of this case, is we're talking about, you're talking about, should she have said something? She never got that opportunity to say something. And even if she did, she could have been ignored. I mean, what plaintiff is really arguing here is you should have made sure she didn't leave. That's the ultimate issue in the case. And we can never prevent her from leaving. So you want to say, well, you may be able to talk her out of it, but you're talking about someone who made up this scheme, who lied to everybody, who decided she wanted to go back to the life, and then when she goes back to the life, now she wants to sue us for
So
having...
again, counsel, you have no, so you don't even try, because you believe that she's concocted this scheme, so there should not be any attempt, is what you're saying?
No, because we actually did try. Remember, on November 7th, when she was on leave with her mother, she had absconded for the night with this pimp. We then, when we found out about that, took action, and we put her on one-on-one, and we didn't take her to GEMS. But at some point, because GEMS is a court-ordered program, she's got to go back to GEMS. She's got to continue with her treatment. So we had a whole treatment team evaluate her, not just one person, a whole team, and they came to the conclusion, based upon her lies, that she didn't want to go. She realized that she didn't want to do this anymore, and there was a plan that if she felt this way, she was going to talk to someone. So she erected this whole thing and then got the opportunity to go. Now, if we had been waiting right outside and stopped her, she might have left the next day. She might have left the next weekend when she was with her mother.
But at least
She
under
was
those
bent on
circumstances,
leaving.
but couldn't you at least under those circumstances, had any of those scenarios occurred, have said, you know, we have exercised our duty here. We're a non-secure facility. We attempted to convince her not to leave, and she left. Isn't that a very different case than what we're presented with?
No, because you're dealing with someone who's bent on leaving. So whether we talk to her or not is not going to matter.
You're on notice that you're dealing with a child who's been trafficked, who clearly has severe psychological issues, correct?
Yes.
So don't you then exercise a duty as a reasonable, prudent parent under the circumstances so that she doesn't abscond?
What you're talking about is a situation where maybe the family court or maybe ACS should have put her in a lockdown facility or in a mental hospital or something that had a higher level of care. That everybody, it's undisputed that our facility did not have that high level of care. So if you're going to go to a facility that doesn't have a high level of care, you can't hold them to a standard of a higher level.
So then you should have said, you know what, there's nothing we can do for her, so therefore, we're not the program for her.
We didn't realize that till after she left.
Thank you. Let's see, last up is Kufeld versus New York Presbyterian. Two minutes.
Good afternoon, Your Honors. Nick Gershman on behalf of the plaintiff respondents here. Since I'm here on my own, I will be brief. The parties here agree that Mr. Kufeld suffered gentamicin toxicity, which caused serious symptoms. So the only issue here is whether the way in which gentamicin was administered and the way in which trough levels were monitored violated the standard of care. There's a clear issue of fact on that point. Plaintiff's expert clearly opines that the standard of care is checking daily. Defendant's expert, Dr. Marr, calls it, quote, ideal, but says it's not the standard of care. And that's a classic dispute of fact. There's additional facts in evidence that support plaintiff's expert here, including that Dr. Suave, the treating physician, initially had decided that these trough levels were to be monitored daily, and then changed that note. In order to dispute this, appellants raise an issue that essentially they say, well, had we changed this dosing regimen at all, then Mr. Kufeld would have died. But they forfeited that argument by raising it only in their reply brief. The initial affidavit from their expert is very clear. He says, quote, there is no evidence in the records to indicate a reason to stop the gentamicin. That's at page 77 in the record. It's only in his reply affidavit when he states it still would not be an indication to stop or change the method of dosing. And by bringing it up in the reply, of course, they robbed us of the opportunity to respond. But even so, even if you credit this argument, or even if you were to consider it, plaintiff's expert's report is sufficient to create an issue of fact on this point.
Thank you. Thank you very much.
Thank you.
Eric's everywhere. Eric's everywhere.
Thanks. Resistance.
Yeah, you know.